and the views on it. Parties to arbitration case decided to refer their disputes to the arbitration, and during the arbitration process they decided to settle. The matters that were referred to the arbitration are limited to specific matters that does not include all their disputes that arise out of the agreement. But when they decided to settle, they decided to settle all their disputes that were included in the arbitration agreement and others that were not included in the arbitration agreement. And they asked the arbitration panel to issue an award with regard to the settlement agreement, provided that part of the issues are not included in the terms of reference and were not included in the disputed matters that were referred to the arbitration. Would the panel accept to issue an award that is outside their scope, even if the parties agree to settle all their disputes? Is this a matter that may be subject to challenge in the future?
Well, I think that the advantage of arbitration is that it is led by the parties, and it is actually up to the parties to put together the terms of reference for the arbitrators. So, I mean, in this particular case, we are talking about a consent award, if I understand correctly. So it's a case in which the parties have settled, and they would like this to take the form of an award. I mean.
But the main issue is that there are some issues that were not referred to arbitration, but they decided to include it in the settlement agreement.
I mean, to be honest, once the parties have agreed, it would be, if you think in theory, you wouldn't really see why they would go and challenge afterwards an award that they have agreed on, right? But to be on the safe side, I would actually supplement or amend the terms of reference of the tribunal, just to have that as a basis, you know, or yet another proof that the parties had agreed to that, and then I would actually have the award on all the issues, and you would have then two elements of proof on which you would base the agreement of the parties.
Can I add something? I don't know if you mentioned that. You know that ICC have developed a mechanism which is dispute board resolution mechanism and clauses where you when you draft a contract, you have a provision stating that you will have one expert. You will have one lawyer / one arbitrator / one mediator and someone from the company. And for any disputes arising during the implementation of the contract, being minor dispute, you will refer to this panel that will have to issue a recommendation. You have to decide whether it's 48 hours or 6 days. And so it helps like support the parties during the implementation of the contract. And you have always those like little recommendation. And I think it's useful. It's not really what you were experiencing in your case, but it could be something that you can think about when you draft your contract, because it's super useful, because anytime they do have a doubt or they are feeling that there is a tension arising, they go to this dispute board panel, and you do again have an expert or someone from the legal background and a mediator, and they're always trying to settle everything, so the conflict can't really be out of proportion.
Sorry, if I just can add something on that. Yes, but, and I think that this is particularly useful, in very long in very long contracts where you have a lot of phases, a lot of stages of implementation, and each one of the stage can actually gives rises to, for example, the payment of a payment, or you have to make sure that you have completed a certain phase in order to have another phase starting. So yes, for very long procedures in which you have a lot of stages, this is yes, the dispute boards are clearly. Construction, for example, is one of the sectors where it is extremely used.
Thank you.
I'm sorry. I don't know if you are interested, but preparing this conference, I came across a good paper from the University of Texas, which is, we don't have a lot of doctrine yet in mediation, but this article is very good. It's a good summary of what is subjectivity in a mediation process and how, as mediators or as lawyers, you can guarantee the process in terms of fairness. So the title is from the university, the paper is from the University of Texas. The title is Fairness, and if you give me just 1 minute, I can also give you from my phone the name of the author. But I thought it was a very good paper and a very good summary, so anyone who is interested, it's worth. It's Shapira, Fairness, and you can have the PDF online. And it's a very, very good, it's a good article, a very good summary. So it's worth reading if you are interested in. No, it's not Shapiro, no. I know. Yeah, I thought, but it's not, no. Thank you, sorry. No, Shapira.
Shapira.
Yeah.
Okay, thank you very much. Do you have any other comments or questions regarding the topics? Okay.
I understand that you worked before with a number of arbitrators. I just want, this has been bugging me for quite some time because we prepare so much documents in an arbitration. Sometimes it could fill in a room to be able to prepare our claims, our defenses. Having worked with an arbitrator, do they actually read through all of these documents? It's just a thought that comes to mind every so often. It's really bulky, it's really heavy, but the documents are really voluminous. I don't expect you to tell me how they analyze it, right? But based on your experience, how do they weave through the numerous documents?
So there is one arbitrator who does this. No, I'm kidding. So I actually, I think that it's also our fault of councils, and it's also the fault of the parties, to be honest, that we are reaching that. And I think any single arbitrator you talk to, they will complain about exactly the same thing. They will complain about the fact that we are not managing to be to the point. We are always trying to develop every single point. And as I gave an example before, fair and equitable treatment, given that I know I've been spending a lot of time with that standard, you can write 200 pages on it, but is it really useful to detail every single one of the cases, which is the dealing with fair and equitable treatment, or can you actually deal with a couple of pages to the point? But the problem is, this is the problem of international arbitration these days, is that every single case is interesting, and you are trying to make a case by using the newest case out there, and we are reaching to this kind of cases where you have hearings which are going on and on for days. But on the other hand, and I think Mark said that yesterday, is that you as a party feel that you are making all the right points, and technically you are really using every single one of the possibilities to make your case. So in a way, it is, I think, a little bit counterproductive because it takes much longer than it should be. But yes, cases became more and more complex, and when it goes into technicalities, you feel that you have to make the point. So. But I think all arbitrators complain about the same thing, to be honest.
I came across a firm that in construction disputes that they visualize the dispute in a short video with a comment supported by documents, and they give a clear picture of the disputes to the tribunal in a video, small video, and it helps a lot. I don't know the name of the firm, but in order not to appear like I'm marketing their work, but they perfectly present the case in a video with a summary, and they refer to all the documents in the case in a half-an-hour video, and it also gives a good idea to the tribunal. This is just for information.
Just as to supplement my observation, it doesn't mean that we don't have complex cases. We actually handle complex cases. More recently, we handled transmission lines, electricity. And it's really very hard that we have to explain through every document. But what really puzzles me is there are hearings, successive hearings, on particular dates, and there is also a date upon which they will come up with an arbitral award. And usually it's maybe, depending on jurisdiction, maybe 90 days, or from the time of the last presentation of evidence or the last submission. Of course, different people have different ways of studying. I just, forgive me for asking that, it's just like, I wanted to know, based on how arbitrators go about with studying the cases that we prepare.
Yes, but you see, the thing is that I don't think you can generalize in arbitrators, like, and then I think Mark wanted to add something on that. I don't think you can generalize on arbitrators. I think you have to, you are appointing your arbitrator. So, you know, you have to choose the person who has the technical capacities and who has the time. I mean, of course, you have extremely famous and extremely respected arbitrators, and obviously if they are there is because they have an amazing knowledge. But if you know that they are already involved in 5 cases, even though you think they are the best for your particular case, you are not going to appoint them because they will not have the time, and they will do, probably they will end up dealing with your case, but not at the speed that you would like to. So what I think the arbitrators do these days is that they really have, you know, tribunal secretaries are extremely important. They are actually trying to make some summaries of the parties' pleadings. They are trying to help with the arbitrators. And I also think that most of the arbitrators these days try to decide as soon as possible after the last hearing, because everything is fresh in their memory and they are managing to do it much better than having a lot of time afterwards.
If I just add to directly answer your question, I think there's good and bad in every way. I mean, there's good and bad judges. So when I was back in the UK, you knew if you had a certain judge, it would be a bad day. But it's the same with arbitrators, in that you can pick well-reputed, well-respected, well-known, and they will normally be the busiest people. So,
of course.
I mean, I had a hearing in November, but we're still waiting for the final award. But we allowed it to slip because he was in the Supreme Court last week as an advocate. So we know that they. The good ones will read it. I had their case. The bad ones, and sometimes you've got a case where you've got a good one and a bad one on the panel, because obviously different people set up them. You can see that they're glossing over because they haven't read the documents and things, and then you can only hope that the guy who's read it in the arbitration room will drive the conversation, and that may be to your advantage or not your advantage. So just like the judiciary, good ones will have read everything, and they won't be grateful if you fulfilled their workload with a load of irrelevant stuff, but they would have read it.
And I also want to add and to reflect on what the lady of, I don't know your name, was mentioning before. I also think it's arbitrators and mediators that have to be like stricter in saying, in terms of like keeping up with the schedule, but also lawyers, you have your responsibility, and that's also how you create value for your client. You have.
She's called Virginia. What lady?
The one in the back in white. Yeah, sorry. I think it's also our added value as lawyers. You have to be as synthetical as possible, and it's sometimes you can develop the same points. And it's, I mean, I got a report, someone from a law firm at the DJ competition here in Brussels. It was, I think, again 200 pages. So I went through all of it, but like frankly, there were pages like giving us all the explanation about European policies in competition and all the case laws. I mean, I'm exaggerating, but not so much. And I was like, okay, there are at least 30 pages that you can just, I mean, you can refer to the case law, but again, you are addressing someone who is supposed to have some competencies and some skills. So you really have to do, like, I mean, you can't really, I mean, expect everything, I would say, from the arbitrators or the judge or the mediator. You also have an added value as lawyers. And Joanna was mentioning earlier at the very beginning of the first session that you have to keep it simple and very short. I think you agree on that.